Morning.
Our first case is State of Ohio versus Anthony Cunningham. We only have the appellant here to argue. The appellee waived. You'll have 15 minutes to present your argument. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims during your argument. You can refer to them by initials or terms like the child. We have read the briefs and are prepared to proceed when you are.
Judge Carr, Judge Wanzer, Judge Stevenson. May it please the court, I am Richard Kuda, Chief. I am counsel court appointed for Anthony Cunningham. This court has a unique opportunity today to set some rules, to make some clarification. Imagine having a jury trial where the key, one of the main witnesses is a corrections officer who's wearing correctional gear, but also is your wife. And that person comes in and identifies you and gives testimony against you, but then later comes and says, wait a minute, I lied, that's not what happened. I notice my opponent and colleague is not here today, and there's a reason for that. The state can't dispute what has been argued here by the appellant, and more importantly, they don't think this issue is important, but the reason they're not here is they don't have anything to say, and you can find
They filed a brief response, they had things to say. I mean, we could assume they think this is such an open and shut case, they don't even bother to show up, so I think it's best not to assume anything about why they're not here. Let you make whatever argument you'd like to make today.
Well, I appreciate your honor, except for one thing. I disagree with you how the appellee addressed the matter, but notwithstanding, okay, most of the time, when the state has an appeal, the appellee says it's a no-brainer for the state. Now the appellant is saying it's a no-brainer off of common sense alone. I felt it's important to come here, even though the briefs were so articulate and really detailed, because I think it's an important issue, and I guess I posed this question: what is the problem with having a hearing? So here we have.
Okay, but first of all, I commend you for being here, Mr. Kuda, Chief. I always like when people are here for oral argument. I commend you for doing that and being here today. The case law is fairly clear is that there's a burden on your client to show that they were unavoidably delayed from having this when they don't file within 180 days. They don't have a hearing. So that's the question before us today. And I know you want to go to the merits and talk about, look, we have this wonderful argument on the merits, but what did your client show specifically to show that he was unavoidably delayed from producing this information within 120 days? That's the bottom line issue of argument.
And I appreciate that, Your Honor, except let's also not confine it upon an impossible burden beyond a reasonable doubt. That's not the burden.
By clear and convincing evidence, I don't think anyone's saying it's an impossible burden. What did your client specifically show?
Well, I think the state says that's very clear. I mean, here's what my client said. So here's how the time.
What did your client, when you say your client said, your client filed an affidavit to say why he could not produce this?
Well, it's a little bit more complicated than that. First of all,
that's a simple question though. Did he file an affidavit or not? You can tell me if it's needed, but did your client file an affidavit below? I looked through the record and I see an affidavit from the wife or ex-wife, I'm not sure, the relationship. I see that.
Sure.
But I don't see anything from your client in an affidavit saying, I did X, Y, and Z to try to do this. Am I missing that in the record? Was anything like that ever produced?
Judge Stevenson, I would not suggest you're missing that, but what I think we're all missing, if we look at the state's persuasion here, is that the state kept saying, well, the case law, the this, the that, but what they did not say is how do you discover a recantation? That's what this case is all about. So let's take a look.
Couldn't that be in an affidavit, how you discovered it? Like you could infer that you were doing research on the case because I know I didn't do it, and then talking to her again, she recanted. Couldn't there be some details about how the discovery of that recantation?
Well, I don't think that's essential in terms of persuasion.
Well, because then I think the issue is then you can, if you don't say that, then it can be considered conclusory, which we do have some case on.
Yes, Judge Lenzinger, that's exactly the point here. What burden do we place to get to a hearing? Here's the deal. So to answer your question, Judge Stephen, first of all, we need to look at a couple things. My client just came down off of a direct appeal. This court just issued a decision in August. The next thing we know, in September, my client asked for a lawyer. The next thing we know, in October 2nd, he files a motion and says these things. The court just discovered from an affidavit that the witness recanted. So do we have to have an affidavit for let's talk about fairness here. What's the right thing? Here's the question. What is the problem with having a hearing? So wouldn't you think,
But don't we, if you're talking about the burden of unavoidable prevention, somebody could have recanted, this could be a 10-year-old case, and somebody could have decided they were gonna recant 2 years after the case like we have here. Don't you have to detail how you were unavoidably prevented from knowing of a recantation? Don't you at least have to have the burden of describing how that occurred?
So your standard would be, if I understand it, I'm sorry to interrupt for your question, but seem to me your standard is basically if someone says they show up with recanted testimony, that at that point there should be a hearing.
well, let's be clear on what we're trying to get. We're trying to get a hearing to have the ability to file a motion for a new trial. We're not even...
I understand that. That's what I'm asking. Are you basically saying if there's recanted testimony, you should at least have a hearing? The court decides whether or not it's credible or not and makes a determination for a trial.
Yes, in this case.
And that's fine. I'm going to make sure I understand what you're saying.
That's what's so clear. That's what's so distinctive about this case. In this particular instance, bring the witness in, let her explain it. She couldn't come to court because she was ill. And so when we talk about the burden or what's required here, how do we get to the notion that, take a look at the factual basis the state itself has provided. When you look at the factual basis on page 3 of the government's brief there, you're looking at a main witness identifying this person. Now, wouldn't it make sense, and I appreciate Judge Lenzer, you're talking about 7 years, 10 years, but this is 2 years. So let me get back to the agenda. We talk about a direct appeal. The trial court has no jurisdiction. You can't file a motion, so let's file a motion right after the verdict. And we're gonna say this, hey, the victim of the witness was lying. Well, that's not gonna get us anywhere, we know that. So when you start to look for, I'm gonna call up my ex-wife, I'm gonna call her up and say, hey, are you gonna recant? So the issue, bottom line is, the unavoidable delay issue is there because you don't know what a witness is going to say upon recantation. So when you look at the timeline, direct appeal, September 2nd, file a motion for trial. October 2nd, put in my motion. Look what he writes in his motion. So do you need to have an affidavit? So where are we getting? We're getting to where we want to have a hearing. The parties agree that Rule 33 provides for a new trial within 120 days. But it makes sense to keep things moving, to end litigation, sure. But again, what if this key witness all of a sudden says, I lied? Now that's not a time where she's thinking about it, or a time where the witness is saying, well, I'm not sure. The witness is saying specifically and distinctively, I made it up. The rule provides for this, and you have to provide clear and convincing evidence that he was unavoidably prevented. He's not saying it was because he was in prison. He's saying, obviously, he didn't know until the person came forward and said, I'm recanting. So the case cites from the state is offering persuasion to these legal theories, but the rule does allow the exception for greater than 120 days. And in this instance, if you look at what the state is saying, I invite this court to take a look at the distinctions that are made in the state's argument and figure out, well, what particularly is it that they are addressing.
Could you refile this request with more information? Is that if there is some story of how he learned, can you put that into the motion? Couldn't you just refile?
I think that's a good point, and unfortunately for me, I'm appointed appellate counsel, and so once we're here, we're not there. So if I were to say, and I think, things went pretty well down below, it's not exactly how I would have done it. There was a lot of confusion as far as I'm concerned in the record, how things were working. If it were me, I would make certain that person was there sitting in front of the court. And I think that's something that can be looked at. But if we look at common sense, because I think it's critical that we have common sense when we're looking at the issue of not whether a new trial should happen, but whether we can file a motion for a new trial.
What was the delay in this case from the time?
I'm sorry?
What was the delay in this case from the time the defendant heard about or knew about the recantation and how long things were filed?
I did not know that, but I do know this. If there's a direct appeal, that's that. You're not filing anything in the trial court. But I know also...
So if during the appeal, this woman had, again, is your wife or ex-wife? I'm sorry, I forget from the record. This is the witness here currently ex-wife?
I did not know the answer.
I don't either. I know wife was wife at one point. So
correct.
At any rate, this at least wife, former wife, whatever, had a year into the case said, hey, you know what? I want to let you know, Mr. Cunningham, that I lied. I decided I was emotionally upset about what things were going on, and I'm upset about this. Could they have filed for a new trial then based upon the recanted testimony, or did they have to wait for the appeal to be over?
I think you have to wait to an appeal because the trial court has no jurisdiction. Right? So how do we get in here? But that's not what happened. That's not what the record...
We don't know what happened. Is that fair? You say you don't know what the delay is. And in my reading of the record, we don't know specifically when she told him, I'm recanting.
Do we have any information, I'm sorry for interrupting you, do we have any information that there was a delay? In other words, when did she file her affidavit?
Well, that was filed along with the motion, so I can't, unfortunately, that's what the record does not provide for that. But
You're in a bind.
Here's the deal though, Your Honors. Let's talk about unavoidable delay. Come on, let's talk about justice here and what's fair. So tell me this, if you're sitting on the trial court, you're telling me you wouldn't want to hear from this witness, one of the key witnesses who comes and says she's lying. Come on,
Well, counsel, you've been around long enough to know, and no offense, I've been around long enough too.
Yes, Judge Carr. We were younger at times.
You've been around long enough to know that unfortunately people decide to change their minds, and you have to decide when were they telling the truth, then or now. So it's not necessarily so unusual for somebody to recant their testimony.
And that may be so, and I think if and when that happens, that's when we move into the phase of a motion for a new trial. Let's get to the substance. So we're hung up on this is what's so critical about this case, and this is why this court can do something about it.
No, but you're asking us to get to the substance, but there's a threshold question that we have to get to first, and that's unavoidable prevention. I mean, we can't even get to the substance unless we determine.
But I'm not sure.
That's what the law is.
Let me ask this, Your Honor, as a rhetorical question. How do we get, what would be unavoidable delay when a guy's in prison, he doesn't know anything about recantation, but once he finds out about it's clear in the record. He found out about it and he filed a motion. I mean, that's 8 plus 8.
Well, is that clear in the record without an affidavit from him, or her affidavit explaining when I gave this information to him? I mean, you're saying it's clear in the record, but what in the record tells us this all occurred on these dates and we know that?
Well, that's why I'm saying with an impossible burden. He filed it in his motion. This wasn't the lawyer filing. It was pro se motion where he said that on October 2nd. When we talk about unavoidable delay, we still want to put it in the context of fairness and justice. It was clear what he said, and if you bring in the witness and the witness is convincing, then you have clear and convincing evidence to move to the motion for a new trial. Let me conclude by saying this. If you look at the summary of the agenda in the record, then you see what went on as I just have explained. I think in conclusion here, I asked this court to rule on common sense when it comes to the notion of being able to file a motion for a new trial. That's what this case is all about. You have the ability to make that, to define it more clearly. Don't make it an impossible burden, because that's what happened here. I know what you're saying, Judge Steve. I can relate to that. But let's look at the big picture and what is the fair thing to do. Come on, let's hear from the witness. Boom. Is there any, if there's no further questions, I see my time is up. I could go on forever, but I won't. Thank you, Your Honors, for hearing me out here. I really appreciate it, and I hope that you feel that we acted here in good conscience and coming on this case.
And again, thank you for being here for the argument. We certainly appreciate it, Mr. Chief, for your argument.
Thank you, Judge Stevens.
Thank you for your presentation. The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the opinion on the day it's released, and also our opinions are posted on the Ohio Supreme Court website. Thank you again.
Thank you, Judge Lindsay.